Hello, everyone. Today we're going to talk about employment discrimination between men and women. And I am Steve Sui.
I'm Yantao.
So let's start.
Here is our table of contents. We've got introduction, the description in China, Germany, Korea, and finally the policy alternatives and summary. First, let's talk about the definition of employment discrimination. Employment discrimination is the unfair treatment of the individuals in recruitment, promotion, remuneration, or job retention on the basis of factors such as gender, marital status, pregnancy, or caring responsibilities. Gender-based discrimination is particularly prevalent and reflect deep-rooted societal biases and structural inequalities. While the sexual minorities are most likely to face more severe discrimination, since most of the relevant policies in this world are now aimed at addressing employment inequalities between women and men. And since these efforts are far from sufficient, today we will mainly divide people into men and women when discussing this topic. The challenge faced by men and women are different. Women, by contrast, face more pronounced discrimination. For example, in China, women are 7% less likely to be hired than men when holding all else being equal. Therefore, our focus today is on discrimination against women in employment due to reproductive-related factors. We should note that this issue is closely related to reproductive justice, as the workplace discrimination is always motivated by women's needs related to reproductive justice, which can then in turn limit women's reproductive choice and exacerbate social inequality. So why we choose this topic? The intersection of employment discrimination and reproductive justice has significant implications for labor market dynamics, family well-being, and global gender equality. Even though many countries are doing a good job of eliminating the employment discrimination between men and women, no country can confidently guarantee that they have fully addressed this issue. That said, this problem still afflicts nearly half of this world's population. And we choose China, South Korea, and Germany as case studies examples because of the diversity these countries exhibit. Understanding this difference helps us to find effective strategies to mitigate discrimination and then promote inclusive practices.
Now, firstly, let's focus on China's situation. China has made remarkable strides towards achieving gender equality in workplace, and you could say that China's achievement is listed below, and also both in recruitment and in promotion, China are facing with very severe problems. Let's find out what are they. The first one is gender specific job aids. In Chinese government's 2020 National Civil Service job list, 11% of the postings specified a preference or requirement for men. In both the 2018 and 2019 job lists, 19% of the postings specified a preference or requirement for men, and in 2017, the rate was 13%. Among the nearly 14,000 job postings in the 2020 list, 6% specified a preference for male applicants and 5% specified a requirement for male applicants. The discriminatory job posting often state frequent overtime work, heavy workload, and frequent travel. And China are also having a marital and maternal bias. After China ended the one-child policy and it began to allow couples to have more than 2 children in late 2015, working women in China have increasingly faced pregnancy-related discrimination. Some women have felt lawsuits or pursued arbitration against the employers who dismissed or demoted them or cut their pay after they're becoming pregnant. And the weakness in enforcement are also noticeable. Anti-gender discrimination laws and regulations in China provide few specific enforcement mechanisms and are not effectively enforced. Since 2013, several women have brought successful court challenges over gender discrimination in job aids, but the compensation imposed on violators in the low hundreds of United States dollars was so inconsequential that it was not an effective deterrent. And also, COVID-19 has impacted the whole economy, which also exacerbating this situation. And in promotion, China are facing with very severe middle management bottleneck and glass ceiling for women. Despite higher university enrollment and graduation rates than men, and a slight edge in inter-level roles, women's representation drops sharply to 22% at middle management and only 10 to 11% in senior leadership. And China also has structural differences in Chinese workplace. Women directors are 2 to 5% less prevalent in state-owned and prevalent enterprises than in multinational companies. Women dominate sectors like health, social work, and education, but remain underrepresented in mining and construction. And low comprehensiveness in the equality level in the workplace is also very noticeable. Women in China face persistent workplace inequalities, earning 23% less than men on average, and experiencing higher rates of job loss and longer reemployment times, especially during crises like COVID-19.
China's legislative framework for combating gender employment discrimination is guided by the constitutional principle of equality and the right to work. Core provisions are found in labor law, employment promotion law, and the law on protection of women's rights and interest, supplemented by administrative and some local regulations. The labor law explicitly guarantees equal employment right, thus prohibiting discrimination and ensuring protections for women, particularly during pregnancy, childbirth, and lactation. For instance, women cannot be dismissed or laid off during this period. Additionally, female workers are entitled to maternity leave for at least 19 days and related benefits. Despite these legal frameworks, challenges remain. First, there is no unified anti-discrimination law, and relevant provisions are scattered across various legal documents, leading to inconsistencies. Second, many existing laws provide broad principles rather than some actionable definitions, making enforcement difficult. For example, the scope of employment discrimination is narrowly defined, and proving discrimination is challenging for the affected individuals. Third, the mechanisms for addressing violations, such as legal remedies and accountability measures, lack clarity and efficiency, resulting in limited deterrence against discriminatory practices. The implementation of these laws has made progress in the raising awareness and protecting women's labor rights. However, the fragmented nature of these regulations and insufficient enforcement has limited their overall effectiveness. So, strengthening legislative cohesion and creating clearer enforcement mechanisms could further advance gender equality in the workplace in China. And now let's look at Germany. In Germany, even for jobs where discrimination in employment is relatively common, such as engineers, the studies did not find significant evidence for gender-related employment discrimination. Germany has developed a strong legal foundation to combat the employment discrimination, particularly regarding gender inequality. We can see that this framework is grounded in the basic law, which enshrines the principle of equality in it, prohibiting discrimination based on gender. And there are also some key legislations that includes the General Equal Treatment Act (AGG) and the Federal Act on Gender Equality, which establish specific measures to ensure fairness in recruitment, promotion, and workplace practices. For instance, German law prohibits requiring pregnancy or contraceptive certificates during hiring and discourages employee selection based on career breaks, reduced working hours, or caregiving responsibilities. Additionally, the work councils required under the Work Constitution Act provide platforms for ensuring women, includes the migrants, access workplace information and professional opportunities. This move provides a clearer path to enforcement. Germany approach also aligns with European Union directives, incorporating anti-discrimination provisions, such as the Act implementing European directives, putting into effect the principle of equal treatment, which is known as the EDET also, and amending existing laws to strengthen the equality in employment. For example, caregivers are supported through re-entry initiatives, and the employers are encouraged to implement fair recruitment practices. Despite the Germany progress, the gaps remain. One of the main issues is that the government's limited enforcement power in private sectors due to collaborative bargaining agreements and a lack of direct regulatory oversight in many private companies. This means that while public sector organizations tend to implement these policies effectively, many private firms still fall short in providing equal opportunities, especially for the migrant women. Furthermore, while Germany has made significant progress, the law still has some gaps in terms of practical application. The policy on re-entry for the caregivers, for example, are not always fully implemented. And the effectiveness of the work councils in truly empowering women, particularly migrant women, in decision-making positions is still a work in progress. Overall, Germany has laid a strong foundation for gender equality in employment, but there is still work to be done to close the gap in enforcement and ensure that these laws benefit all women equally, including those from marginalized communities like migrant women.
Okay, now let's focus on South Korea's case. According to OECD's data, South Korea has the largest gender pay gap among OECD countries, with women earning nearly one-third less than men. Despite high levels of tertiary education among women, their labor force participation rate remains about 20% lower than men, significantly above the global high-income country average. And the women there are also bothered by the workplace harassment and stereotyping. A significant proportion of South Korean women report experiencing workplace discrimination and harassment. Surveys reveal that over half of female employees face inappropriate remarks or are tasked with stereotypical duties such as preparing coffee. Sexual harassment is also prevalent, with women receiving unwanted advances 3 times more than men. And the labor market in South Korea heavily penalizes women with families. Married women, especially those with children, are much less likely to remain employed compared to their unmarried counterparts. This child earnings penalty results in many women leaving the workforce entirely after childbirth, rather than negotiating reduced hours. And industrial representation disparities are also noticeable. Women are underrepresented in leadership and high-paying industries such as finance and technology, and are overrepresented in low-wage sectors like healthcare and education. This structural issue reinforces economic inequality and limits career progression opportunities for women. And finally, recruitment and promotion biases are also severe. Gender biases persist in recruitment and promotions. Nearly 25% of women reported facing discrimination during hiring processes or in promotions, compared to only 7.6% of men. Age and marital status are also common factors influencing hiring decisions. And this problem indicates a very serious status of the current career's status in employment discrimination. Now let's find out what has been done to address this problem. There are main 5 acts, and let's introduce them. The first one is Equal Employment Opportunity and Work-Family Balance Assistance Act. This law prohibits discrimination in hiring, promotion, and pay based on gender. Employers must ensure equal opportunity for women, particularly after marriage or childbirth, and penalties are imposed on non-compliance. And the second one is Workplace Harassment Prevention Act, which was enforced in 2019. This law bans discriminatory practices and harassment based on gender, marital status, or other personal characteristics in the workplace. And the third one is anti-discrimination bill. This bill proposed legislation aims to comprehensively outlaw discrimination in employment, including bias based on gender, age, marital status, or sexual orientation. When not yet enacted, it represents a significant step toward addressing workplace inequality. And the next one is gender wage transparency. The government mandates companies to disclose gender-based pay data, allowing authorities to monitor wage gaps. And finally, the last one is employment support programs for women. Those programs were designed to help women re-enter the workforce after childbirth or caregiving. These programs provide job training, career counseling, and entrepreneurship support to minimize career interruptions caused by family responsibilities. That's the policy examples. Now we have already know about the cases. Let's find out what policy alternatives we have. We have 4 main orientations. Let me introduce those policy alternatives to you. The first one is to improve childcare and family leave policies, to expand subsidized childcare services and ensure that both parents have equal and mandatory parental leave, encourage at the same time uptake of paternity leave through financial incentives, and to develop flexible childcare credits that allow parents to choose between public services and private care options. And the second one is mandating gender diversity in leadership. This act we need to do is to implement quotas for female representation on corporate boards and in senior management positions, similar to Norway's model. And we need to provide government grants or benefits to companies that voluntarily adopt and achieve diversity benchmarks. And the third one is to enhance workplace training and awareness, mandate regular anti-discrimination and unconscious bias training for all employers and employees at the same time, to establish public campaigns to shift social norms about gender roles, targeting schools, workplaces, and media. And finally, the last one is to strengthen the re-employment support for women. We need to expand vocational training and mentorship programs to help women return to the workforce after career breaks, to launch a government-backed job matching platform, especially for mothers and caregivers to re-enter the labor market. We believe that these four alternatives would be more than helpful in all the cases we have mentioned. Now we have already known the cases in China, in South Korea, and in Germany. Let's find out what's similar and what's the differences. The situation of employment discrimination in China has improved in recent years, but underlying systemic discrimination remains serious. South Korea, also an Eastern Asian country, shows the same discriminatory trend due to its culture and economic development model. Despite its relatively well-developed economic system, both China and South Korea have loopholes in the legal regulation of employment discrimination. And despite the existence of relevant legal constraints, efforts are still needed in the enforcement of the laws. At the policy level, the two countries also show similar policy tendencies. Policies are favor restraining the hiring behavior of enterprises and enhancing the competitiveness of workers in employment, which have had little effect in concrete judicial practice. One of the main problems for Germany is the limited capacity of the government to enforce in the private sector, partly due to collective bargaining agreements and the lack of direct regulation of many private firms. At the level of implementation of specific policies, although to a lesser extent, there is a similar problem of implementation bias. So that's all about our presentation. Thank you for listening. If you have any questions, further discussions would be more than welcomed on Canvas. Thank you.